Today I want to talk about marital property rights in Texas. Texas is a community property state and has strong homestead laws protecting individuals' homes. When the title company produces a title commitment, they must address one important exception. We must determine the marital status of the record owners at the time of and at all times subsequent to the acquisition of the subject property and require the joinder where applicable. This means that it is crucial for us to know that the owner's current marital status, as well as their status at the time of acquisition and throughout the ownership of the property. So let's discuss when a spouse needs to sign the transfer documents. Generally, a spouse must sign if the property is homestead or if both spouses are in title. A homestead is defined as 10 contiguous acres in the city or 200 acres in the country, and all property is generally treated as homestead unless the owners designate another property as their homestead under Texas law. If the owners designate another property as their homestead, they will both need to sign a non-homestead affidavit for this property that they are trying to sell. In addition to the homestead rule, in Texas, property is either separate property or community property. Separate property is generally defined as property owned or claimed before marriage or acquired after marriage through gift, devise, or descent. Devise means property acquired via a will, and descent means property inherited when someone dies without a will. Community property is everything else acquired during marriage. If a person is married, property is presumed to be community property unless the spouse can provide evidence that it is separate property. So essentially, absent a valid prenup or postnup, unless it was owned before marriage, gifted, or inherited, it is community property. Whether a property is separate or community property can have a big impact with regards to what happens to the property upon death or divorce. However, many sellers do not understand that Texas law provides that, regardless of whether the property is separate or community, neither spouse may sell, convey, or encumber the homestead without the joinder of the other spouse. So, if you have a seller who believes their spouse does not need to sign their transfer documents, your first question should be whether the property is homestead or not. And if it is homestead, the spouse must sign, even if the property is separate property. If it is not homestead, the other spouse may not need to sign the deed if they are not in title, but they may need to sign a non-homestead affidavit. Contact us to determine if the spouse needs to sign and what steps are necessary for the specific situation. As always, let me know your next idea for the tip at tipoftheweek@allegiancetitle.com.